You might think that having a will means your last wishes will be honored, especially when it comes to distributing your hard-earned money. But here's where it gets surprisingly complicated and potentially controversial. Some perfectly legal processes can actually override your will, no matter how clear your intentions are. Let's start with a trend that's gotten people thinking. U.S. readers might have heard of Swedish death cleaning, a proactive approach to decluttering your possessions before you pass, sparing loved ones from emotional turmoil and unplanned arguments about your stuff. But what about your money? That's often a much messier situation if you don't set things up correctly. Here's what most people overlook. Naming beneficiaries directly on your major financial accounts, like 401ks, IRAs, life insurance policies, annuities, and sometimes brokerage or bank accounts, is actually more powerful than what you write in your will. Surprised? You're not alone. Many assume the will is king, but when it comes to these accounts, whoever you've named as beneficiary will legally inherit the funds, full stop, regardless of anything contradicted in your will or trust. To quote estate planning attorney Jeffrey R. Gottlieb, when there's a designated beneficiary and that person is alive, their claim trumps your will, unless you specifically listed your trust as the beneficiary. Here's the part most people miss. When you name beneficiaries directly on an account, those assets get transferred quickly upon your passing. They avoid the long, often stressful court process known as probate, where your will is authenticated, debts are settled, and whatever's left is distributed to heirs. Skipping probate saves time, emotional energy, and frequently, money. But here's where things can get tricky, and yes, even spark fierce family debates. Suppose you forgot to update an account, and your ex-spouse is still listed as a beneficiary. Or maybe you outlived someone you named years ago. In these cases, your money could end up with someone you never intended, or in confusing legal limbo. Gottlieb emphasizes that major life changes, think divorce, new marriage, a birth, or a death, should always prompt a beneficiary review. Will your assets go where you actually want, or could a decades-old decision haunt your heirs? Now, what happens if your beneficiary passes away before you do? That's not always straightforward. Who's next in line? The answer depends on what you filled out on your original forms. For example, if you've left 50% of your retirement account to your brother and he dies first, who gets his share? His kids? Your other beneficiaries? A charity? Without clear instructions, this is where arguments and confusion flourish. Gottlieb suggests thinking ahead. Do you want a beneficiary's children to step into their place or not? And here's a detail people often overlook. If you never designate a beneficiary, most accounts default to your estate. According to John Rossi, an attorney with a background in probate litigation, this means your money joins the estate's assets and heads straight to probate court. And if you pass away without a valid will, state laws, known as intestacy laws, decide who gets what, sometimes in ways that might surprise or dismay your loved ones. For example, some 401k plans could automatically assign your spouse or children as beneficiaries. But rules differ by state and plan. Have you checked how yours works? But just as named beneficiaries help you dodge probate, so can setting up a trust, a tool that's not just for the ultra-rich anymore. Yes, creating a trust may involve more upfront effort and cost than writing a will, but it provides extra flexibility. Think about these scenarios. Maybe your kids are minors, or you have an adult child who struggles with addiction, or a disabled child who will need ongoing support. If those children are listed as direct beneficiaries on your accounts, the money will go to them immediately, possibly before they're ready to handle it responsibly. But if you establish a trust and name it as the beneficiary, you can spell out exactly when and how they'll receive their funds, ensuring long-term security and peace of mind. But here's a potential flashpoint. Decisions about trusts and beneficiary designations must also account for taxes and recent legal changes, like the Federal Secure Act, which now requires many heirs to withdraw inherited IRA funds within a specific time frame. Don't risk choosing options that backfire for your family. Always review these with your estate attorney. One final, bold reminder. How often do you really review your old financial paperwork? If you have policies or accounts from years ago, you might have named people whose circumstances or relationships with you have completely changed. Take this as your nudge to double-check who's currently listed as your beneficiary, and make sure there's still the right choice based on today's reality, not yesterday's plans. And if you never named anyone at all, there's no time like the present to update your documents and spare your loved ones a future headache. Let's open it up. Do you agree that beneficiary designations should have so much power, possibly even above what's written in your will? Is that fair or potentially dangerous? Tell us your thoughts and your biggest estate planning questions or fears in the comments below. This one could spark some real debate.